As always with these sessions, I'll be happy to take any questions at the end of the same. Okay. So first of all, brief introduction. The law was the new law was never in force. It is still not in force today. The ruling is a preventive measure that is established in the Portuguese Constitution that allows specific actors in different roles, whether the president, political parties in parliament, may request the Constitutional Court to take preventive action on certain bills before they enter into force. So we will be looking at three issues. Number one, which aspects were ruled unconstitutional. Number two, which were not ruled unconstitutional. And number three, the way forward. I should also note that certain issues that had been raised by the petition filed by the Socialist Party have not been discussed by the Constitutional Court and therefore would remain valid. So first of all, one of the issues that was deemed unconstitutional was the fact that a 2-year prison sentence would bar the applicant from submitting an application. So that the new provision, or the one that was included in the law, said that granting of citizenship would depend on applicants not having been convicted by a final and unappealable court decision to a prison sentence of 2 years or more for a crime punishable under Portuguese law. So this provision was ruled unconstitutional, basis of which is that this provision does not justify or assess to what extent the application of the sentence would jeopardize the link of integration into the Portuguese community. Of course, this might be of little relevance. None of you, I presume, would have any specific issues with this. Nonetheless, it did, of course, can affect a number of applicants and therefore was part of the review. Also, the bill included a provision whereby the acquisition of Portuguese citizenship could be opposed in the absence of effective ties to the national community, including demonstration of behaviors that would overtly reject the adherence to the national community, its institutions, and symbols. Once again, the Constitutional Court found fault in this provision, and the basis for that is that the standard regarding the need for legal regulation is sufficiently high that the definition of what constitutes a necessary and sufficient demonstration of behaviors that conclusively and overtly reject adherence to the national community cannot be delegated to the bodies responsible for applying the law. Okay, so essentially what the court is saying is that this provision is not, number one, sufficiently justified, and number two, it cannot be delegated to bodies responsible for applying the law, in this case, the government. The new law also contained a provision whereby the possession of Portuguese nationality, original or acquired for at least 10 years, is grounds for consolidation, even if the act that gave rise to its attribution or acquisition is subject to administrative or judicial declaration of nullity. And also, this consolidation would not apply if the possession of nationality was obtained in a manifestly fraudulent manner. Again, this would not directly apply to any of you, but nonetheless, this is another way where Portuguese citizenship might be obtained upon a fitted possession. Originally required for at least 10 years and could result in that consolidation. But again, due to the absence of any criteria that distinguishes or properly distinguishes between fraudulent and manifestly fraudulent acquisition of citizenship, is the reason behind its ruling as unconstitutional. So there's a lack of precision in the definition of what manifest fraudulent acquisition of citizenship might be. Fourth and final aspect that was ruled unconstitutional is of greater relevance to you. The new provision that was included in the bill says that approval of applications for the attribution or acquisition foreseen depend on the fulfillment at the time of their submission of the requirements of the citizenship law. In the wording, in the current wording, meaning not the one that was recently amended, because once again, that has not entered into force, but simply the citizenship law as is applicable right now. The Constitutional Court found fault in the fact that the fulfillment of requirements to be assessed for the purpose of a citizenship application is to be measured at the time the decision is being made, not at the time of submission. So the court offered an example, such as one of the criteria, as we know, for submitting or successfully applying for citizenship is the lack of any criminal record. So no record of any criminal record. So in this example, the court says that if the criminal record shows some kind of criminal activity at the point of submission, but it is in the process of being expunged, and if the applicant were to show before the decision is actually made on his or her file that the criminal record was successfully expunged, then that would be possible. Meaning the assessment of that requirement would be made at the time where the decision is being made and not at the time of submission. Okay, so this is definitely a relevant point that might affect not just the criminal record per se, but any of the other requirements as well. Moving on to the second point of the discussion, which issues were not ruled unconstitutional. So 3, number 1, the granting of citizenship to stateless persons contingent on residency. That did not affect any of you. Number 2, reverting the computation rule of residency period, and that would affect you. And the absence of a transitory regime, which means no grandfathering rule. So we will concentrate on the last 2. As you all know, the current and still in force computation rule of residency period was introduced in April 1st of 2024. And the basis for that was, as we all know, the backlog of cases that resulted in a excessive delay of processing of the residence cards. So this was viewed as an exceptional measure. And the reason for this exceptionality, again, is the backlog of pending cases. Now, when the current government submitted its proposal to amend the citizenship law, it mentioned that the task force that was implemented, created to clear the backlog, had accomplished its mission. So the massive regularization of pending files had finished, and therefore the cause for the exceptionality was removed. As we know, the proposal was submitted this year in June of 2025, and one of the aims was to remove the favorable computation rule. So the court finds that the state's actions were predictable. And I quote from the ruling, foreign citizens could not consciously believe in the mutability of a regime of an exceptional nature, and this change cannot be configured as unexpected or unpredictable. So essentially, the yardstick that is being used to measure whether this elimination of the current computation rule is constitutional or not has to do with how people perceived or would expect the rule to be applied in the near future. Essentially, the court says that from April 1st of 2024 to June of 2025, this computation rule made sense in the context of what the legislator intended, and therefore the removal of the cause that prompted this new computation rule in the first place. So the clearing of the backlog of cases and the fact that the proposal of new legislation was submitted in June 2025 is indication that that a change was in place or that was forthcoming, and therefore applicants that might be affected by this change of rule could expect such a change, and that the regime is not intended to be immutable or to remain unchanged for the future, or at least the foreseeable future. And with regard to the absence of any transitory regime, absence of any grandfathering provisions, the initial objection was that initial objection to that absence. So when, again, the Socialist Party submitted its request for the preventive review of the law, was that the expectations of potential addressees of the former law are not duly protected, meaning that you, as golden visa holders or residence holders and potential future citizenship applicants, your expectation of accomplishing such a application would not be protected without without this transitory regime in place. So you as investors and future seekers of citizenship trusted the legal framework, invested and followed the rules that were in place at the time, and therefore there is a breach of trust, a breach of that principle, constitutional principle of the protection of trust. However, the court concluded that trusts can only be placed in the immutability of the law at the moment of submission of a citizenship file, meaning an applicant can only trust that the law will not change with regard to file lodged until the new law enters into effect. So if you file an application under a certain set of rules, then what you expect is that those rules should apply to your case. But only that kind of protection only applies to those who file their citizenship application at a certain point in time, which means that the law can be changed in the future, and therefore, whether it affects applicants in the future is to be expected. And well, before we go on to the way forward, some issues were not even discussed, not part of the court's analysis, specifically the raising of the residency periods to 7 years for those applicants that come from Portuguese-speaking countries and 10 years for everyone else. That was simply not part of the discussion and therefore not deemed unconstitutional. In terms of the way forward, what happens now? What would be the next steps? Well, after the ruling, the president will veto the bill. So once again, current rules still in force. 5-year rule still in force. Computation from the date of submission of the application still in force. The bill must be redrafted to address any unconstitutional issues. The probable dates for the new discussion in Parliament would be February, March, due to the fact that there will be the presidential election will take place in January. And once again, until that moment, the old law still applies. So anyone who would be in a position at this point to file a citizenship application will still benefit of the 5-year rule and the computation of 5 years from the moment the residence application, the GV application, was first submitted. Okay. Now, for those who might not be able to make it in time, we're looking at, of course, an intermediate step, which is to secure either permanent residency or EU long-term residency. It's 5 years for either case. There are little differences between both regimes. The second one, EU long-term residency, would make sense for those who might not have Portugal as their final destination, but might be thinking of living, working, studying in a different country. So it's an EU framework, not a national framework, and is better suited for those who might be moving around the EU. So it allows easier, quicker residence in a different country, different EU country. Then, once again, for those who might need the full 10 years, would apply for citizenship under the new rules if the new discussion will have that similar outcome, yet to be seen. And of course, we would have to address the potential challenges for those children of main investors who become of age in the meantime. So conclusions, way forward, reassess when the law has finally been enacted and published. We're still some months away from that. And we don't know how the new discussions in Parliament will turn out. So any basis for assessment will have to be measured at the appropriate time. And at which point we should take a look at evaluating permanent residence or EU long-term residence conditions, remain on the citizenship path. Number two, divest eventually, if that should be your choice. Consider other countries or programs. So we're looking at Spain as a plan B for some of our clients. And C, eventually consider merits of litigation, but this is still unripe at this stage and would definitely need the final law to be in force before we can even consider that option. In any event, we will still, of course, be monitoring next steps and provide advice on a one-to-one basis for those of you. But let me, as a final word, highlight. I've done so during this session, but nevertheless, it's worth repeating. Number one, those of you with citizenship applications that have been submitted, everything is per usual. You will not be affected by any change in the law. And the Constitutional Court has granted as much. Number two, the new law is not yet in effect. So we will still have time. How much time exactly is unknown. But for those of you who might be in a position to apply for citizenship, we can do so now, or we can still continue to do so. Okay. So that's all for me right now.
Yes.
I would like to thank you all for your patience and attention, and like to open the floor as well for any questions. So there's one question in the chat box. case submitted application February 2023, biometric done in March 2025, when I get my card. Well, we don't know yet. The
Okay.
issuance of,
Okay.
yeah, kindly turn off your mics, please, for those who kindly turn off your mics. As I was saying, the approvals don't come in regular or strict chronological order. The last ones we've seen pertain to 2023. And even back in October, if I remember correctly, we even had some approvals from November and December of 22. So these approvals jump around, going back and forth. Could be July of 23 and then back to February of 23. And this has to do with many different issues. We have been explaining over our reports and emails that different offices, different officials, different understandings, family configurations with more members, less members, those who might have filed or not filed a subpoena against IMA, all of these can affect in various ways the speed of processing. Any other questions? So it is likely that for citizenship application, initial 5 years will still be 10 years from issuance of card to apply for citizenship. Well, it is certainly possible because number one, the raising of the number of years was not challenged, was not reviewed. And it is foreseeable that when the discussions reopen sometime February, March, that will not be part of the discussion, or at least I don't think that the government or any of its allies in Parliament will revert to the 5 year. Okay. And yes, the issuance of the card and not the actual application or submission of application will be the starting point. So it is expected that the final version of the law will incorporate these two dimensions. A question
Antonio, Farida, yeah?
Yes.
You know, when you said that to answer one of the questions about the citizenship application, initial 5 years will still be 10 years from issuance of card to apply for citizenship, yeah?
Yes.
And you said that it may still be a possibility. But you also said that for those of us who submitted, have submitted or submit now, we will not be affected by any changes in the law.
Yes.
So as far as we are concerned, those who have submitted is still 5 years. Yeah?
Yes, correct.
Thank you.
Sure. Let's see, what else? We had our biometric in the month of March 20, no, that was already replied. Did no one make the argument that the period of required residency is being counted from time of application was a legitimate expectation for applications made from April 2024 to June 2025? No, so the analysis of the court meant that for that interval, And people submitting and still submitting for that matter, citizenship applications, they should be protected and they should still benefit of the current rules, meaning 5 years of residency counted from the moment the application is filed. From the moment the application is filed, and of course, provided that the card is approved. Okay, so it's not just 5 years from the moment of submission. The file needs to be approved. So, and there are also two different elements here at play. One is I'm applying for a golden visa application, but that's a residence application, which might or might not lead to a citizenship application. Okay. So the idea that was submitted for the review of the law, that there are legitimate expectations on behalf of future citizenship applicants, that there was a trust placed in a certain set of rules being applied to them. The court rules that such trust is misplaced because you can only expect certain rules to be applied at the moment you submit your application, and that the applicant should not expect certain rules to remain unchanged forever. We can agree or disagree, and I find that the absence, this is my personal opinion, the absence of a grandfathering rule is definitely damaging. And for Portugal, as a country that has received millions of euros from investors. And I find it that it does breach the principle of legal certainty. But that would be matter for a different discussion. Another question, the card is for residency under golden visa and our 5-year residency period is counted from our 2022 application date despite the 2026 biometrics timing since the delays on the government side. Is that correct? The 5-year rule, again, is still in force. So let's imagine that the 10-year rule only enters in force, let's say late 2027. So if we would still have time at that point, if you have fulfilled your 5 years, let's say in early 2027, then you can avail of the 5-year rule from the moment you submitted the application. However, let's say that in April of 2026, the new rules are already in place. What that would mean is that you would have to go through the new rules.
I
10-year already conform, right? If you mean by conform already in place, no. I've said it time and again, and I'll repeat it one more time. 10-year rule is not yet in effect. The law has not been passed or has not been actually enacted by the president. The president, following the Constitutional Court's ruling, must return the law to Parliament for a new discussion. So the 10-year rule, as of today, does not apply. Okay.
Hi, Antonio. Just a quick question. This is
Sure.
Chris.
Yeah.
I want to
Okay.
know what is the uh, legal basis of Portugal, considering when they were inviting investors to invest in their country, the rules were 5 years. Then after getting their money, there's a new rule that says 10 years. Is that even allowed? Changing the rules after getting people's money?
Well, if we look at the reasons that were given by the court, and which I explained just a while ago, the idea of, and I'm not saying that I necessarily agree with this, I'm just trying to explain as best I can of the reasons or the explanation behind the ruling. The court sustained that the protection of an applicant's interest in becoming a citizen is limited to the rules in force at the time of submission. Now, with regard to the 5-year computation rule that is currently in force, which means only 5 years start counting from the moment of submission of the application and on when the card is actually released. The court says, listen, these rules, or any other rule for that matter, is not expected to last forever. This rule was provisional. It responded to a certain context. It was stated as such. The fact that certain milestones have been achieved by the task force that was clearing the backlog, and the fact that when the bill was introduced, was first discussed in Parliament, already was an indication of these changes, and therefore any future applicant could not predictably expect that these rules would continue to apply. Now, what you're hinting at has more to do with if you would like to see it that way, a contract between the applicant and the country. And that's a scenario which might lead to litigation. So if we can actually, and I'm not suggesting any specific course of action here, but if, let's say, the government at the time were to have invited investors to place their money in Portugal with an expectation not only to gain residence in the country, but also to become citizens under certain specific provisions, then that's different, or might be different. Because then you're implying that, I'll take your money in exchange for certain benefits. One of these being you will become a Portuguese citizen after 5 years. And if you consider that a binding contract, then you might have grounds to say that one of the parties has not held up their end. But this is a very different discussion. One that would entail litigation. We're not there yet. We might be there yet. And also, I understand where the question is coming from. Now, of course, the review undertaken by the Constitutional Court does not necessarily limit itself to golden visa applicants, but to any applicant seeking citizenship. And therefore, that expectation is different in each case. Specifically, if, let's say, you were promised by the Portuguese government, invest and you will get A, residence, and B, citizenship. Right? If such promises were made, and if the Portuguese state could be held accountable for making such promises, that would be a different scenario. Because, of course, the subset of applicants that came through the golden visa path has very specific conditions which are not extensive to any other group. Okay. So the Constitutional Court assumed it as true that AIMSF backlog was fixed and there were no more backlogs. Well, it's a bit simplified, if you like. It has more to do with the fact that, and again, the court does not really assess or look into whether the backlog is fixed or not fixed. They're not looking at the numbers. What they're saying is the change of April 2024 of the citizenship law responded to a specific situation. And remedies were put in place to address that situation, meaning the backlog. The task force, for better or worse, have concluded that mission. So what they're saying is, because this measure was introduced, or this rule was introduced to ease the burden of or sustained by those affected by the delays and the backlog, then this rule should not be expected to remain forever. That's the idea. Because we had applied for an investment for Portuguese citizenship, And we had also invested our capital there. We need to ensure that any government changes in rules that negatively impact investment do not affect our investment. So can we appeal this matter in court? Well, that's what I was explaining just now. And it's still, very early since we don't have the final wording of the law and it's definitely not enforced yet. But there would have to be very clear indications, and there might be, whereby the government is promoting the Golden Visa program and saying, as part of its features, and in order to entice investors, that they will be able to apply for citizenship in 5 years. Okay. So that is an important aspect. It's one thing if you say, oh, invest 500,000 and you'll get residency. And it's a very different matter if you say, no, invest 500,000 and you'll get residency, and after 5 years, you'll get citizenship. Okay. And of course, that kind of signal has to come from the government. If the government creates that expectation and then pulls the rug under the investor's feet, then we might have something there. Not sure if it was already discussed, but if the new law gets passed, will it include a transition grace period before enforcement? Well, that's what I was discussing just a while ago. So the Constitutional Court did not find fault in the absence of that grandfathering provision. So we need to see what the final, at least second attempt at getting the bill passed will look like. We don't know. It is foreseeable that it might not change much, except, of course, with regard to the issues that were targeted specifically by the court as unconstitutional. Those will have to be removed or amended in some way. With regard to the other contentious issues, I'm not sure which direction things might go. So we can only make that assessment once the final law has not only been passed, but specifically enforce. Okay. Any other questions? Okay, if there are no further questions, then we're at least not. So we have to expect our cards by next year, or how? We're still getting these approvals from time to time. And I can even say that a specific group that had been targeted, more or less, and whose applications were being delayed, even more so, Russians. And this week we've received a few approvals for Russian applicants. So these approvals are still trickling in. We're seeing some consistent action, not perhaps as fast as we would like, but on a regular basis, every couple of weeks or so, we're getting new approvals. For which year they're giving approvals now? As mentioned, there is no method to the madness. Okay. Over the past months, we've received for 2022, we've received for 2023. There was even one very early applicant in 2025 who was resolved or approved very quickly. I don't know how or why, because there are no explanations given as to why some people are approved faster than others. By way of explanation, I can only refer the same arguments that I gave a while back, which means different offices. Also, as we know, the Lisbon office, which is the most burdened with the number with existing or ongoing files, has been distributing or redistributing files to other offices throughout the country. So a file that was initially submitted in Lisbon might be approved somewhere else. So it might just happen that a certain person's file was redirected somewhere else and therefore got the approval earlier. Already 10 months we did biometric. Yes, I know that. I'm perfectly aware. That's a card received biometric date. Well, as I mentioned, the last ones usually pertain to the first semester, inching now towards July of 23. And we might have the odd approval in 24 or 25, but not really consistent. If we're looking at regular, consistent approvals, these are more within that first semester of 2023. Okay, so if, well, we're coming close to an hour now. If there are no further questions, I'll end the session now, and the video will be uploaded onto our YouTube channel. Okay. We will be sending the link once this has been completed. Thank you all for your very kind attention. And as always, we will be providing further updates as things move along, including any other queries you might have that might be specific to your own personal situation. Okay, so thank you very much and have a great
Thank you, Antonio.
Thank you.
Thank you all. Bye-bye.
Bye-bye.